Good afternoon, everyone. Hello. In today's lecture, we begin. This is the continuity of administrative law series of lectures that we have been doing on administrative law. But today we begin this most intellectually important lecture on administrative law. Up until now, we have discussed meaning of administrative law. We've tried to understand the objectives of administrative law. We've tried to understand the scope and the significance of administrative law. And we've tried to understand the reasons which led towards the growth of administrative law. That we have discussed in our lectures up until now. Today we move into a more foundational philosophical debate. Now, this debate that we're going to discuss today, it concerns the relationship between administrative law and the rule of law. So, today we discuss this debate, this relationship between administrative law and the broader concept of rule of law. What is the relationship that they have with each other? So we're going more into the detailed aspect of today's lecture. And at the depth, at the very core of this debate, the relationship between administrative law and rule of law, at the very core of this debate, we have this very important scholar called as A.V. Daichi. Now, Daichi theorized on, he's synonymous with rule of law. He talked about rule of law. He remains one of the most influential ideas in context of constitutional law as well as administrative law. So, however, Daichi held a very critical view of administrative law, which we'll come to understand in our subsequent lectures. So, he took a very critical view of administrative law. That's why understanding Daichi is important because his ideas shaped the Anglo-Saxon tradition. Anglo-Saxon tradition of administrative law. Remember, Anglo-Saxon is this United Kingdom-led, England-led system. So this English system, which finally went on through their colonies, it went to gain a foothold in all over the world. So today we are going to discuss this philosophical debate. We're going to discuss Daichi's view of administrative law. We are going to understand Daichi's doctrine of rule of law. We are going to understand the key principles of rule of law. We're going to understand Daichi's criticism of administrative law, of course, and we are going to understand the relevance that Daichi's theory hold in modern governance, इसके context में. Then we're going to, of course, see from the Indian constitutional perspective, what that holds for us. So, without further ado, let's start with the background of Daichi's thought. Okay. So before understanding Daichi and his thoughts on administrative law, it is important to understand the background in which Daichi wrote, theorized, in which Daichi came up with his thoughts. So you'll have to understand Daichi is writing, is theorizing, is thinking in which context. उस टाइम पे चल क्या रहा था? So he wrote in late 19th century. Late 19th century. And this was the time period when Britain was very proud of its constitutional values. Britain was very proud of its constitutional values. British, in fact, at that point of time, British system had emphasized on parliamentary supremacy. British system had emphasized on parliamentary supremacy, that parliament is supreme, no king is supreme, no queen is supreme, it is the parliament which is supreme. So it was at that point of time, and Britishers, they were very proud of that. Their system of courts, ordinary courts, ये बहुत प्राउड थे अपने कोर्ट्स पे जो जस्टिस डिस्पेंस कर रहा था, and the concept of equality of law. So it is in this background जिस टाइम पे Daichi जो है, he starts theorizing upon his ideas. ये वही टाइम था जब ब्रिटिश सिस्टम जो है वो एम्फेसाइज कर रहा था इन चीजों पे. इसके कॉन्ट्रास्ट में यूरोपियन कंट्रीज सच एज फ्रांस, फॉर एग्जांपल, they had developed a separate administrative court system to deal with disputes involving government authorities, something called as droit administratif. So they had a single British system had one single set of courts जो administer कर रहा था, justice सारे adjudication वही देख रहा था. और ये वही टाइम था जिस टाइम पे फ्रांस started developing France had started developing something called as the dual system of courts. Dual system of courts. Dual system of courts. It was called as droit administratif. So France at the same time, when these had when England had this single system of courts, it was at the same time that that France had developed this dual system of courts of administering justice, one for the common people and one for the administration. So different set of courts implementing different laws. Dual set of courts, hence referred to as the dual system. The dual system of courts, called as droit administratif. So it's at the same time this is happening. And in this backdrop, Daichi strongly opposed this French system because he believed that government officials should not enjoy special legal privileges. Under this system that France had, you had two sets of laws, one for the common people and one for the administration. While as England at that point of time had single ordinary courts. Daichi, once he started understanding it, studying it, he opposed it vehemently and he said, दो अलग-अलग set of कानून नहीं होने चाहिए. Ordinary citizens के लिए एक कानून और बाकी लोगों के लिए दूसरा कानून. Ordinary laws adjudicate होंगे एक set of courts से और दूसरे वाले through other set of courts under the dual system. He opposed it vehemently. And he said there shouldn't be two different set of courts. Why should government officials have special legal privileges? So according to him, all individuals, including government officials, they must be subject to the same administration by same ordinary courts under this legal system. Anglo-Saxon legal system. And this idea became the foundational foundational idea of his doctrine of rule of law. Daichi is very well known for rule of law. And this idea became the foundation that there shouldn't be two different set of laws. Why should there be privilege for a certain class, administrative class in this aspect? So this became the foundation. So he pontificated, he promoted one set of courts, and in that way, this idea became the basis for his doctrine of rule of law. Now, what is Daichi's rule of law? He's considered synonymous, just like Max Weber. We talked about Max Weber being synonymous with bureaucracy. In the same way, Daichi is very much synonymous with rule of law. Daichi argued that British Constitution, according to him, was characterized by supremacy of the rule of law. According to him, British Constitution was characterized by supremacy of the rule of law. Now, he explained this doctrine, this rule of law. He called the British Constitution as something which inherently has supremacy of the rule of law. Now, to explain it further, he explained this through his doctrine, through three core principles. And these three core principles, these principles by Daichi, they remain central to the constitutional and administrative law even today. He's writing in 19th century. Even today, his concepts, his theorizations remain relevant. So his first principle is Daichi's first principle. He says, supremacy of law. Supremacy of law. Law से ऊंचा कोई नहीं. Law से बड़ा कोई नहीं. So according to Daichi, no person can be punished. You cannot punish anyone or made to suffer except for a breach of law established through ordinary legal procedures. Write it. Write it. So first principle is supremacy of law. According to Daichi, no person can be punished or made to suffer except for breach of law, except for the breach of law established through ordinary legal procedures. So the very first principle of Daichi's rule of law, where he says that law in itself, any person, whimsically you cannot punish someone, you cannot abuse someone, you cannot make anyone suffer. You can only do so if that person has breached a law. That can only be done once a person has breached some law. And these laws they're made through a process, they carry a purpose. So, अगर कोई कानून है और कानून breach किसी ने किया है, then that person can be punished. And this principle actually implies government authorities cannot act arbitrarily. They cannot act on the basis of their whims and fancies. It curtails the government authorities who have power to act arbitrarily, to act in a certain fashion that they like. Every action taken by the administrative authorities must be supported by legal action, legal authority. So, just because government has power, bureaucracy has power, does not mean that they are free to do anything as they like, anything and everything as they like. But they have to have the legal authority to do what they are doing. Thus, this arbitrary exercise of power is incompatible with rule of law. You cannot have rule of law and you cannot have arbitrary exercise of power at the same time. If there is arbitrary exercise of power, there cannot be rule of law. And if there is rule of law, that curtails arbitrary exercise of power. So, in this aspect, what is happening is that rule of law is made in essence to curtail the excessive arbitrariness, to curtail the discretion of the administration. So that is supremacy of law according to him. Then principle 2 of Daichi's rule of law, that is equality before law. Equality before law. This is the second principle of A.V. Daichi. Daichi argued that all individuals, regardless of their status, they must all be subject to the same law, regardless of their status. Are they rich? Are they poor? Are they from this background? Are they from that background? Is he a male? Is she a female? Regardless of anything, they should be subjected to the same law. This includes ordinary citizens, this includes government officials, it includes ministers of the government. If murdering someone is a crime for an ordinary citizen, murdering someone is a crime for the minister. Murdering someone should be a crime for the bureaucrat, government official. So regardless of if dacoity and loitering is a crime in case of citizens, it should also be the same case in terms of government officials and ministers. So this includes all of them. That's why equality before law. No official should enjoy any legal privilege, which would bar them otherwise from coming under the ambits of equality before law. So all these disputes must be resolved according to Daichi by ordinary courts applying the very ordinary law. So no separate set of courts, as was the case in context of France at that point of time. So this principle rejected that idea of separate administrative courts for government officials. Okay. Now, principle 3. And it is, according to Daichi, it is the constitution being the result of rights. Constitution as a result of rights. So this is the third principle of A.V. Daichi. This third principle that is proposed by Daichi, that constitution is the result of the individual rights, rather than the source of those rights. Right? According to Daichi, constitution is the result of individual rights, rather than the source of those rights. Is the result of individual rights rather than the source of those rights. इसको बहुत अच्छे से समझ जाना. So according to Daichi, क्योंकि इंग्लैंड के कॉन्टेक्स्ट में लिख रहा था, so and in 19th century England, which we talked about, so according to him it was a time when in Britain in particular जो individual liberties थी, they had developed gradually based on the interpretations by the judiciary. जुडिशियल डिसीजंस से जो इंटरप्रिटेशंस आए उनसे राइट्स आहिस्ता आहिस्ता इंडिविजुअल लिबर्टीज वो सैंक्टिफाई हुए. ठीक है. सो अकॉर्डिंग टू हिम द इंडिविजुअल लिबर्टीज डेवलप्ड ग्रेजुअली through judicial decisions rather than a written constitution. So when judiciary started interpreting, it is in the interpretation and its decisions when it started adjudicating, in those adjudications and in those interpretations that individual liberties they developed. ठीक है. For example, freedoms जैसे कि personal liberty, freedom of expression, protection from unlawful detention, all of that, they were secured through the decision of ordinary courts. ये कोई कहीं पे कॉन्स्टिट्यूशन में पहले ही नहीं लिखा था जिसकी बेसिस से ये हुआ, ये इंटरप्रिटेशन था, उस इंटरप्रिटेशन की वजह से ये राइट्स आए. So according to him, individual liberties developed gradually. We're trying to understand constitution as a result of rights. It is the result of rights. It is not the source of rights. According to him, it was in these judicial interpretations of the courts that when it started talking about personal liberty in its interpretations, in its expressions, freedom of expression, when it started talking about protection from unlawful detention, it's in all those interpretations, in all those judicial decisions that liberties, individual liberties developed. So that's why Constitution emerged as the product of judicial proceedings of rights. Constitution बना उसकी वजह से, Constitution की वजह से right नहीं बना. It's a very important thing to understand. So, I hope you understood it. This is Daichi's third principle of rule of law. Okay. Now let's try to understand Daichi's view on administrative law, जिसके context में हम ये सारी exercise कर रहे हैं. His view on Daichi's view on rule of law. Daichi's view on administrative law. Now, this is extremely critical to the concept of administrative law. Because he was very critical of the very idea of administrative law as it developed in the continental Europe. So you'll have to understand, he was very critical of the rule of the administrative law as it developed in the continental Europe. He believed that administrative law जो है, it created special legal privileges for government officials. Administrative law जो है, which we have understood up until now in our lectures. So it talks about, he is very apprehensive. He says that this administrative law, which gives the administration the power, which keeps it away, which makes it different. This administrative law, according to him, it created special legal privileges under which administration is acting. So he was very critical because he believed it's creating special legal privileges for the government officials. See? So according to him, administrative law created special privileges for the administration, for the government officials. Okay. So that's why he was very critical of it. Uh, in countries like France, जो भी disputes होते थे around administrative authorities, they were handled by these special administrative tribunals, which we talked just in the beginning of this lecture. And according to Dicey, he argued that such systems violated the principle of equality before law. वो जो इसका पहला principle था of equality before law, which is principle of equality before second principle of equality before law, administrative laws उसको administrative law का आना, administrative law का in vogue होना, उसका emergence, उसका very being is very critical to the idea of equality before law. क्योंकि अगर equality before law है तो special privileges किसी को क्यों? So government officials and citizens are supposed to be governed by same set of laws. Then there needs not be another set of laws and not necessarily not another set of courts. So in that point in time, France में जैसे हमने देखा था चल रहा था. So Dicey he argued that such systems violated the principle of equality before law. According to him, government officials जो हैं, they should not be judged by special courts. They should also be judged by the same ordinary set of courts, जिसमें ordinary लोग जो है वो same law के under काम कर रहे हैं. So Evidaishi therefore concluded that the British system had no administrative law in the continental sense because they had one set of courts. And according to him, he said because he was looking at it only from the system of not the evolution, वो हम आज समझ चुके हैं. In our previous lectures, we have understood about the evolution of administrative law. We've read different scholars now who talked about administrative law serving different purposes. Their very definitions are different. Someone is talking about administrative law as being a resistance, a bulwark to the administrative action, while someone is calling it as clothing the administration with power to action. So we have understood all of these concepts in our previous lectures. Dicey at that point of time called it administrative systems in England, in continental Europe, being absent when it came to administrative law. Administrative law being absent. Administrative law being absent in context of continental Europe. So instead, according to him, Britain rallied on the doctrine of rule of law. It relied on the doctrine of rule of law. Now, let's try to understand Dicey's criticism of the France's dual administrative system, right administrative. So Dicey's criticism of the French administrative system. Dicey's criticism of the French administrative system. So he criticized this droit administrative. Under this system of droit administrative, administrative disputes, they were decided by special administrative courts. So in their sense, they had excuse me. So in context of that, the system that prevailed in France, disputes where the government was involved, they were decided by the special administrative courts where administration was involved. Daichi believed that this arrangement gave government officials special protection from ordinary legal accountability. So this system of joint administration is giving these officials an undue advantage. He argued that such systems could undermine individual liberty. So that's why he was very much critical of it. Daichi therefore praised the British system where government officials could also be sued in the ordinary courts. The relevance of his ideas in today's times is established by the fact that his ideas contributed to the development of modern administrative law. It is his ideas that have contributed. Why? Why did that happen? Because he emphasized on rule, his emphasis on rule of law encouraged the creation of legal mechanisms. It encouraged the creation of those legal mechanisms to control the administrative power now. So that's why he remains relevant, because it was, you should write it, his emphasis on rule of law, encouraged the creation of legal mechanisms to control the administrative power. And modern administrative law को जब हम और detail देखते हैं, modern administrative law in fact displays various characteristics. It displays various features which are consistent, which are totally in sync with the conceptualization, the theorization of A.V. Daichi. For example, legality of administrative actions. That is based on rule of law and is consistent with Daichi's concept of rule of law. Judicial review, that is consistent with his theorization. Equality before law, which modern administrative law also upholds, which is consistent with the Daichian philosophy. Procedural fairness, which is consistent with his theory. So Daichi's theory continues to influence contemporary administrative law in that sense of the word. Let's try to understand if there's any relevance that we can find in context of the Indian Constitution. Let's see if we can find anything relevant in this aspect. His doctrine of rule of law had a profound impact on Indian constitutional law. Indian Constitution does not explicitly mention the phrase rule of law any place. However, the concept is very much, the concept of rule of law is very much deeply embedded in several constitutional provisions. So rule of law is not directly mentioned, does not explicitly talk about it, but let's say, for example, Article 14 of Indian Constitution. Article 14 of Indian Constitution, Article 14 जब आप Indian Constitution का देखते हैं, this article guarantees equality before law and equal protection of law. Equality before law and equal protection of law. . Article 14 talks about equality before law and equal protection of law. Now, this directly reflects Daichi's second principle of rule of law. So it is a direct manifestation of that principle. Let's talk about Article 21. Now, this article says that no person shall be deprived of life and personal liberty. No one should be deprived of life and liberty except by law, except by the procedure established by law. Get it? So it's again talking about the procedures of rule of law. So we find Daichi present there also. In context of judicial review, the context of judicial review, okay, Indian judiciary has time and again emphasized that administrative actions, they must be, all of the administrative actions must be very fair, they should be very reasonable, they should be non-arbitrary. And these are the fundamentals of rule of law that Daichi also talked about. So Indian legal system strongly reflects Daichi's rule of law in that aspect. So Daichi's ideas up until now, you must have understood, they reveal a very deep concern about the dangers of unchecked administrative power. He opposed them because of a reason. He feared that the expansion of these administrative agencies might weaken the individual liberties of people. Okay? In fact, although his criticism of administrative law may appear to be very, very outdated today, जो मगर इससे emphasize legal accountability पे किया, जितना he talked about his emphasization on legal accountability, that is still relevant under the contours of administrative law in contemporary times. So there he is still relevant, क्योंकि most administrative law, modern administrative law जो है, it attempts to achieve the balance between Daichi's in fact, it is trying to establish a balance, the modern administrative law in its true sense. It's trying to establish a balance which Daichi sought. That is a balance between administrative efficiency and curtail and the use of the one making the administration efficient enough, and the other empowering the administration in such a way to making it efficient, to not giving it enough so that it turns dictatorial. Ensuring enough legal accountability, ensuring that the citizens' rights are protected at all respects, in all respects. So Daichi's concept of rule of law, it remains one of the foundational principles of democratic governance up until today. और ये हमें बार बार डाइची के कॉन्सेप्ट याद दिलाते रहेंगे, और हम कि no authority in the state is above the law. कोई भी अथॉरिटी स्टेट में कानून से ऊंची नहीं है, जिसको इसने अपने पहले प्रिंसिपल में ही सुप्रीमेसी ऑफ लॉ के अंडर ही कवर किया था. सो एडमिनिस्ट्रेटिव लॉ को इंश्योर करना है ये चीजें कि एडमिनिस्ट्रेटिव पावर ऑपरेट करे, बट विद इन द लीगल फ्रेमवर्क ऑफ लीगैलिटी, फेयरनेस, अकाउंटेबिलिटी, इसके अंडर वो काम करे, इसको इंश्योर करना होगा. मॉडर्न गवर्नेंस में रूल ऑफ लॉ continues to serve as the moral and legal foundation of administration. You should even write that down. In modern governance, rule of law continues. In modern governance, rule of law continues to serve moral and legal foundation of administrative authority. Moral and legal foundation of constitutional of administrative authority. Sorry. Yeah. Now we understood it from his point of view. अब आप अब हम उस टॉपिक को समझने जा रहे हैं जहां पे it is important that you understand it with cons. That's what your exam expects you to do. To understand the both sides of the coin. So now we are embarking upon criticizing, criticism of Daichi's criticism of Daichi. So, अब heading दो Daichi and the evolution of modern administrative law. Daichi and the evolution of modern administrative law. Criticism. Okay. Now we'll look at it from the other side, from the other angle. Abhi tak we understood the ideas of Daichi, doctrine of rule of law. We understood up until now कि Daichi किस तरीके से Daichi ने argue किया कि government officials जो हैं they must enjoy the same law administered by ordinary courts. They shouldn't have any special courts for them, and he strongly criticized that in context of France. However, modern जो states हैं उसमें वो expand हुई है बहुत ज़्यादा. Modern states have expanded a lot. Several scholars have started questioning Daichi's conclusion. Right? So we have moved far from there. They have argued that Daichi's theories जो हैं वो, although they're very influential, they were incomplete. The theories were incomplete. He was already taking into consideration continental Europe or us time ka. They were unrealistic and they are unrealistic in the context of modern democracies, modern governance. This is what these contemporary theorists are saying. So today we will examine now, going forward, we'll examine these criticisms that Daichi's theory faces. Okay. So the first criticism that Daichi faces, and one of the biggest criticisms that he faces, is that Daichi ignored the reality of administrative institutions. So the first criticism that Daichi faces is that he's ignoring in his theories, in his theorization, in his concepts, he is ignoring the reality of administrative institutions. Uh, by this, let's try to expand it a little bit. Daichi wrote his theories during a period when government functions were very, very limited. It was 19th century, government had limited things to do. But during the 20th century, role of the government had changed very dramatically under the garb of the welfare state, जैसे हमने समझा है अभी तक. Modern governments जो हैं, they began regulating complex sectors like industrial production, complex sectors like labor, complex sectors like financial markets, for that matter, environmental protection. So all these aspects which the traditional governments were not doing, the modern governments started embarking upon regulating these things. And to manage these activities, governments created specialized administrative agencies. The NGT, the SEBI Securities Exchange Board of India, the Federal Bureau of Investigation. We created specialized agencies because the domain of work had changed. ये चीज डाइची के दिमाग में नहीं थी. So that's why the first criticism, that he ignored the reality of these institutions. Critics argue in this aspect that Daichi's theory did not adequately recognize this institutional transformation of governance. So that is one of the first criticisms that Daichi faces. Another important criticism that he faces is that he misinterpreted the French system. So this is another criticism that Daichi faces, that he misinterpreted the French system. He had criticized the French droit administrative a lot. We talked about it. And he had argued that it created a special privilege for government agencies, government officials. However, later scholars जो हैं, उन्होंने point out किया कि डाइची का interpretation जो था वो misleading था, क्योंकि French administrative courts जो हैं, they were not designed to protect the government per se. They were not designed to protect the government officials from accountability. ये उसलिए नहीं बनाए गए थे. Instead, they were used as specialized institutions for effective adjudication, जैसे आज हम tribunals के केस में करते हैं, जैसे CAT for example, Central Administrative Tribunal, ताकि aggrieved civil servant को speedy justice मिले. So he misinterpreted the French system. That is another big criticism that he faces. So I hope you have understood it up until now. Third big criticism that he faces is that administrative courts, these administrative courts, जिसका वो इतना critical था, they don't necessarily violate rule of law. So it's not necessarily necessary that it's not all the time that administrative courts violate the rule of law. Daichi believed कि इनका existence जो है administrative courts का, it violated the principle of equality before law, जैसे हमने अभी समझा है कि कानून सबके लिए एक होना चाहिए, इनके लिए अलग क्यों, इनके लिए अलग क्यों. Later scholars argued कि ये जो specialized tribunals है, they are not necessarily it's not these tribunals, they're often necessary, very much important in complex administrative systems. इनका होना बहुत इंपॉर्टेंट है। आपने इसको क्रिटिसाइज किया इस बेसिस पे, आपने इसको रिजेक्ट इस बेसिस की किया कि ये इक्वालिटी ऑफ लॉ को एडहेयर नहीं करता है। So, but it is not necessary. So Daichi had done that previously. He had done that previously. Daichi had called out for that previously, that these administrative courts were they were different. They were these administrative courts, French administrative courts, were administrating justice different. So rule of law had to be one for all of them. Rule of law had to be same for the ordinary people, and it had to be same for the officials. But somehow it is important that these specialized agencies come into being, because the nature of this modern governance is such, they are very technical in nature. Modern governance ke issues are very, very technical in nature, or ordinary courts cannot handle them, like taxation, like labor disputes, like competition law, environmental regulation. All of them are very complex issues, and they require specialized agencies. Ordinary courts may lack these specialized expertise required to deal with such matters. Okay? Administrative tribunals therefore provide the efficient and expert adjudication to these disputes. So you are ignoring the fact that they are important. These critiques even argued that administrative adjudication does not necessarily undermine rule of law. It can be complementary to rule of law as well. So in that aspect, this emerges as another big criticism of A.V. Daichi. Another criticism that he faces is that Daichi's concept of equality was too rigid. His concept of equality was too rigid. Daichi had insisted that government officials, they must be treated exactly like ordinary citizens are treated. He had insisted upon that. That's why he wanted that single system of laws to be administered by the single system of courts. However, critics have argued that this approach ignores the special responsibilities and powers of administrative authorities. They have special responsibilities to fulfill. You cannot club them together. You cannot have, you're treating everyone equal, but everyone doesn't have equal responsibilities. That is not equality. So your concept of equality is too rigid. They have responsibilities to carry out, and for that they need a co-equal amount of power and authority, which cannot be extended to each and everyone. A doctor is only supposed to operate. Not everyone can be allowed to operate. So they have different responsibilities to fulfill. For that, your concept of equality has been very rigid. It does not acknowledge that. So modern governance requires these specialized procedures and legal frameworks. Modern administrative law recognizes them, while the officials must remain accountable. So administrative processes differ from ordinary judicial procedures. Ordinary judicial procedures are different, and administrative procedures are different. So, and they are needed, much needed in contemporary governance. Another important criticism that he faces is that he ignored delegated legislation. He ignored delegated legislation. So this is another criticism that Daichi faces, that he has been ignorant of this growth of delegated legislation. Modern legislatures, they frequently delegate rule-making authority to the subordinates. These agencies then create rules and regulations that have the force of law. We have discussed that too in detail in our previous lectures. This development has greatly expanded the administrative authority because now they are into rule making also. They are into law making also, because they were only into execution, but delegated legislation phenomena has increased that to a large extent. So administrative law has emerged to regulate delegated legislation. So it is the phenomenon of delegated legislation which existed, and to counter that, uh, we have seen the emergence of administrative law. That administrative law, that administration remains within the ambits of the statutory limits prescribed by law. So it's to make them lawful, law-bound, that administrative law has established. Daichi's framework did not adequately address this phenomena of delegated legislation. Another very big criticism that Daichi faces in context of administrative law is that his theory was based on limited historical context. His theory was based on limited historical context. Daichi developed his theories, we have been talking about it, during the period when Britain had a relatively small administrative apparatus. Its administrative apparatus wasn't that big. However, in the 20th century, so he was theorizing in 19th century, which we talked about. In the 20th century, the state beginning performing these roles under the garb of welfareism. Various regulatory functions, its scope expanded a lot. ये जो इमर्जेंस था वेलफेयर स्टेट का, ये डाइची के थियराइजेशन के बाद हुआ, और ये जो emergence tha into welfare state, it had mandated the governments to regulate various economic activities, manage large developmental programs, provide full social welfare services. All of that had expanded, transformed the administration and administrative agencies. So administrative law therefore evolved as a necessary legal framework इनको कंट्रोल करने के लिए, रेगुलर एक्सपैंडिंग ऑफ एडमिनिस्ट्रेटिव स्टेट को कंट्रोल करने के लिए, एम्पावर करने के लिए एडमिनिस्ट्रेटिव लॉ जो है वो इमर्ज हुआ. सो आपने हिस्टोरिकल कॉन्टेक्स्ट भी ध्यान में नहीं रखा. और वन ऑफ द pioneers most of administrative law which we talked about, Ivor Jennings, he was one of the most prominent critics of Daichi, A.V. Daichi. Jennings argued that Daichi's theory of administrative law, his view, not his theory, his view on administrative law was historically inaccurate because of just what we discussed. Historically, it was inaccurate, and conceptually, it was incomplete. So historically, it was inaccurate because of just what we discussed, and it was conceptually incomplete because of what all we have been discussing. So अगर आपको question भी UPSC पूछता है according to Jennings, या direct Jennings का नाम ना लेके, that Daichi's view of administrative law was historically inaccurate and it was conceptually incomplete, then this is your answer to that. Today's lecture is your answer to that very question, right? So with this, let's try to understand the Indian perspective. Let's look at, we have some time left. Let's try to understand it from the Indian perspective. Indian constitutional system जो है, जो constitutional system India में established है, वो provide करता है एक excellent example इस balance की, जो हम बस अभी समझ रहे थे between administrative law and constitutional law and rule of law. India recognizes the importance of administrative institutions under the garb of welfareism, because it is India's bureaucracy, India's civil service, which has been the steel frame for India. So, but we also ensure that administrative power remains subject to the broader constitutional control. We try to ensure that administrative authorities in India, they exercise significant power and authority in spheres like economic regulation, environmental protection, social welfare programs. However, these authorities who are engaged in deliverance and of those things, these remain subject to judicial review by the constitutional courts. Constitution has created a system of integrated courts, and these actions are subject to the judicial review by these constitutional courts. Supreme Court has repeatedly emphasized that administrative actions must fulfill the requirements of fairness, reasonableness, and non-arbitrariness. Fairness. So these administrative actions need to be fair, they need to be reasonable, they need to be non-arbitrary. And the Supreme Court has repeatedly emphasized on that. Hence, Indian system integrates this administrative governance with the principles of constitutional rule of law. Okay? So we understood Daichi, and then we understood his criticism also. ये जो डिबेट है बिटवीन डाइची और इसके क्रिटिक्स का, ये एक डीपर फिलोसॉफिकल क्वेश्चन को रिफ्लेक्ट करता है कि कैसे मॉडर्न डेमोक्रेसीज रिकंसाइल कर सकती हैं दोनों कंपीटिंग नीड्स को, क्योंकि दोनों कंपीटिंग नीड्स हैं. एक साइड से गवर्नमेंट रिक्वायर करती है स्ट्रॉन्ग एडमिनिस्ट्रेटिव इंस्टीट्यूशंस मैनेज करने के लिए, कॉम्प्लेक्स इकोनॉमीज को डिलीवर करने के लिए, गुड्स एंड सर्विसेज को, वेलफेयर स्कीम्स को. जबकि ऑन द अदर हैंड साइड डेमोक्रेटिक सोसाइटीज इंश्योर करनी चाहिए कि एडमिनिस्ट्रेटिव पावर जो है इट रिमेन्स अकाउंटेबल, डज नॉट गो आर्बिट्री, इट रिमेन्स लीगली कंट्रोल्ड. सो इन दोनों कंपीटिंग नीड्स को फाइन बैलेंस स्ट्राइक करना इसके बीच में इज द डीपर फिलोसॉफिकल question which needs to be answered. Administrative law इसी context में represent करता है institutional solution to this dilemma. Get it? और ये mechanism provide करता है जिससे administrative authorities function कर सकती हैं effectively, जिससे administrative authorities subject हो सकती हैं to legal and constitutional safeguards. It is the administrative law that intends to do that. Okay? So, Daichi का जो doctrine है of rule of law, it remains an enduring constitutional principle. We have inculcated that in our constitution itself. However, realities जो modern governance की है, they require the existence of administrative institutions, administrative law, or specialized adjudicating bodies in the form of tribunals and administrative courts. So, इसीलिए modern administrative law represent करता है evolution of Daichi's ideas. ठीक? ये preserve करता है core values of the rule of law जो Daichi ने प्रैक्टिस किया, जो उसने theorize किया, while also adapting them to the needs of modern administrative state. Okay? So I hope today's lecture has been very helpful. It is one of the most important lectures in this series. So please rewind, rewatch, get your concepts clear, and अगर कहीं पे problem होती है, please come back to me and let me know about it. ठीक है? Conceptual clarity in matters में बहुत important बन जाती है आपका score करने के लिए आपके exam में. ठीक है? So with this we call it a day. See you guys tomorrow. Bye bye.